Hi Cyber Law class, it's Professor Opterbeck, and I am making this video on the materials from Class 2 for those of you who were not able to attend in person, and I apologize that I didn't have the Zoom link properly set up. So this video will cover what we covered together in person in Class 2. So in this class we're talking about computer crimes and how we think about developing law that covers computer crimes, what we mean by computer crimes, some ideas about criminalization. When is it that we decide that something ought to be a crime rather than something that is simply regulated through the regulatory state or something that is handled through private law? And we'll actually start off with a little bit of a discussion about the problem and the scope of cybercrime. This slide is from one of the sources I gave you to read, and this is a couple of years old now, and the main thing that I want you to take away from this source is that the number of incidents and the costs of incidents continues to go up over time. That was the case a couple of years ago. It is still the case today. And there are a good number of incidents, and it is a costly kind of crime for businesses that are caught up in it and for the whole economy. And you might wonder, given that we pay so much attention to cybersecurity now, why cybercrime would be going up? Aren't we doing a better job of detecting and preventing cybercrime? And perhaps we are, but it is an arms race. It's kind of an evolutionary struggle. The better we get at detecting it and defending, the better the criminals get at evading and attacking. And so it's not something that shows any sign of abating soon. This is from that same study that just gives you a feel for some of the industries that are predominantly affected by cybercrime. And I think you wouldn't be surprised to see banking as one of the main industries that is affected, because the banks are where the money is. You've probably seen in the news some attacks on utilities recently, and it might be a little surprising though to see utilities so high on the list. And the fact is that it's an infrastructure target that is really vital and that is also not as well defended as it ought to be. And then you see some others that you might expect: software, insurance, high technology. Interesting to see automotive here. It's another very big and important industry. Some of this activity may represent attacks on vehicles themselves, but most of this is on the industry, on the companies themselves. This is from another report. By the way, the report in these prior slides is from Accenture, which is a consultancy, and they put out some great materials. The materials in this report are from the 2021 version of the Verizon Data Breach Incident Report. Verizon also puts out a lot of great materials, and their Data Breach Incident Report is one that you should be familiar with if you're in this industry. And this one is showing the patterns of kinds of attacks in breaches and incidents. And so some of the terminology to note here, and this is terminology that we tend to use in the cybersecurity business. An incident is whenever some kind of compromise has happened. Someone has perhaps gained access to the system or put some malware on your system. A breach is when the incident actually results in the exfiltration of some kind of data. And so there is a difference between an incident and a breach, and one of the reasons that difference can be significant is because of state data breach reporting requirements in the US. You're required to report a breach, however that's defined in the relevant statute. You're not necessarily required to report an incident. But in any event, just to notice some trends here, perhaps not surprising again, social engineering is at the very top of the list of the kinds of attacks that are resulting in breaches. And by social engineering, we mean any manipulation of social factors that gives the attacker an initial access point. And so classic example is a fake email that appears to be, say, from someone's bank or from someone's boss, a phishing email, when in fact it is not, and clicking on it then downloads the malware payload. Web application attacks are still important. So websites are not always secure, and in various ways applications can be set up on websites that can launch malware, direct kinds of system intrusion, other kinds of errors. But really notice here that social engineering remains a very important part of the landscape. You might notice here in the incident side, denial of service attacks are the highest. And if you think about it for a moment, a denial of service attack is overwhelming a network so that the network effectively clogs up or crashes and becomes very slow or becomes non-functional. And this can be done, for example, by harnessing botnets that are collections of compromised computers. You can in fact rent a botnet on the dark web and directing queries to a particular site. But a denial of service attack usually is not meant to take information off of the computer, so it's not a breach, but it's an important and costly kind of incident. This slide from the Verizon report just shows some trends. We can see that most attacks continue to be from external actors, although the category of incidents resulting from internal actors, for example, an employee of the company, are still very important. And I know some of you in this class work in dealing with internal threats for organizations like banks. The kind of threat actor, financial motivation remains the highest. Espionage and other is still significant, but it is not the highest on the list. And it's particularly interesting to look on this chart at the top threat actors in different kinds of breaches and notice that the highest one is organized crime. And I'll talk about this in just a moment, but a lot of cybercrime, even though a lot of cybercrime is local, a good deal of cybercrime is the insider threat. There are certainly small potatoes kinds of actors that engage in cybercrime, but pretty quickly the more sophisticated kinds of attacks get connected with more sophisticated criminal networks. And those criminal networks often are connected, at least loosely, and sometimes more directly, with state actors and in places like Russia and Eastern Europe and in China as well. So organized crime is one of the things that makes the problem of cybercrime really difficult. So let's talk for a bit about different possible types of cyber intrusions and the way that they kind of relate to each other. So we saw in that previous study that economic crimes continue to be among the most important. Those studies are looking at costs of data breaches. They're not looking at what I put in the category of personal crimes, which would include things like cyber harassment and cyber stalking, and we are going to be looking at those things in class next week. We didn't see much in those reports that we briefly looked at of hacktivism, and I think hacktivism was probably a more important category a number of years ago, but there still is activity we would classify as hacktivism, which is really cyber intrusions or attacks that are designed for some kind of to make some kind of point or some kind of social statement, and not really directly for economic reasons or personal reasons. Then we can continue to move, and we saw in one of those studies the reference to espionage, and every country in the world engages in some degree of cyber espionage, and the major players, including the United States and Europe, but as well as Russia and the Soviet Union and North Korea, engage in large amounts of cyber espionage, and we will talk about the law relating to that later in the semester. We don't see a lot of cyber terrorism in the most direct sense by non-state actors trying to create violence or fear to make their point. directly. It does exist. It's not predominant at this point, but terror networks do derive financing from cybercrime operations. And so there is a connection, a strong connection there between terror networks and cybercrime. And then, of course, there's the possibility of cyber war. And again, we'll talk about that a little bit later in the semester as well. But cyber war has happened. Russia in the Ukraine has launched cyber attacks that had kinetic effects on the power grid. The U.S. and Israel have used cyber means to knock Iranian nuclear processing plants offline. And whether that's an act of war or not is a disputed question under the international law of war. But the capabilities are there, the activity has already begun, and it's going to continue to be part of the landscape of war. And so if we look at this first grouping, economic personal hacktivism, you have individual actors, you might have loose associations of people, groups like, say, Anonymous doing hacktivism, and then you might, moving up to a higher level, have organized crime. And then if we look at this second grouping, you have state actors and also non-state actors engaged in some of these actions. And what I want you to note is this area of overlap, in sort of like in a Venn diagram here, where the individuals and associations are bleeding into organized crime groups, and this activity then begins to connect with state actors and the often opaque relationship between organized crime, for example, in places like Russia and the Russian state, is part of what makes cybercrime really difficult to police. I wanted to just note the problem of cybercrime during the COVID crisis, and it has been a real challenge. The cybersecurity area has been a real challenge during COVID for a bunch of reasons. One reason is we've seen lots of malicious domains using coronavirus, COVID, things like that. Within the domain, people are searching for information and end up on these sites, which are using web-based attacks to deliver malware. And malware itself malware also embedded in different kinds of utilities you might see on the web relating to the coronavirus, for example, a map of hot zones or things like that. And then really the biggest problem is ransomware. So ransomware is a big problem altogether these days, and ransomware is, the attacker gains control over the data or some portion of the data on the target system and encrypts that data, and then only agrees to decrypt the data if the target pays a ransom for the decryption. And hospitals, medical centers, public institutions that are researching coronavirus have been heavily targeted during the pandemic. And as you can imagine, many of these are places that simply can't afford to not pay the ransom, that is, to not have access to their data. So it is an enormous problem, and it's an even more cyber is an even more difficult problem in a time of crisis like the pandemic. So that's just a very, very brief sketch of some of the costs and the scope of the problem of cybercrime, and there's a lot of literature you can read on this, and everyone really agrees that cybercrime is a big problem. But we're using this word cybercrime, and one of the questions we need to ask, and some of the readings I gave you for this week are really getting at this question, the readings on Aaron Swartz, which is what kinds of activity do we want to say is maybe harmless or even productive, sorts of hacking perhaps? What is perhaps a problem, but a problem that should be addressed through civil litigation, through regulation, in some way short of calling it a crime, and what kinds of activity is serious enough that we want to call it a crime? And why are we drawing that distinction? We're drawing that distinction because to call something a crime brings the full weight of the state to bear on the activity against an individual. And certainly from a liberal democratic perspective on civil liberties, this is where we want to be the most careful. Now, we recognize that we probably need some kind of criminal law. We probably need circumstances in which the full weight of the state is brought to bear against an individual. But we want to be careful about when that happens and how that happens. And one way to think about this is just to consider the possibility of some kind of harm existing between two private actors. And we might say, all right, there's this harm that possibly exists. How should the law, if at all, get involved in adjusting the risks of that harm and of perhaps mitigating or deterring one of the actors from engaging in conduct that would cause that harm to begin with? And the domains of law that I put up here, contract, property, and tort, are domains that we call private law. So for example, let's say that I am private actor 1 and I am supposed to deliver a truckload of bananas to you on next Wednesday, and you own a small grocery store. So we can enter into a contract that sets the terms of delivery and says how much you're going to pay me. And so let's say I fail to deliver. Now, there's a harm there, but it's the kind of harm that we would normally say, we don't want that to be a crime. We bring the weight of the state to bear. We're saying the state can take away somebody's property through fines or penalties, somebody's liberty through putting them in jail, and even in some circumstances, somebody's life through the death penalty. So life, liberty, and property, those key interests that we think civil liberties guard, well, we don't want the state impinging on those just because I failed to live up to my contract. What we want is a system of contract law that says, now you can sue me for money damages or for some other remedy under contract. So similarly with most disagreements about property, so I own a building, you're renting in the building, you break the toilet, who has to fix the toilet? Right? So property rules will come into play and contract rules will come into play, not criminal law usually. And similarly with tort. Tort law is the law of injuries, personal injuries. So I'm driving down the street, I forget to put my blinker on, you don't see me moving into the lane, cause a fender bender, I cause some damage to your car and maybe some injury to your neck. If it's just negligence, then probably we don't want that to be a crime. Probably we want to say, you can sue me in tort, you can recover your money damages. Now, if I'm driving recklessly, or if I am drunk or something like that and cause you serious injury, maybe then we're getting into conduct that we want to call criminal. And in a moment we'll go through some principles that would help us decide. So when we're talking about private law, it's private law, but the state is still involved. The law is created by legislatures, which is part of the state, and or by courts. And so the state is still involved in giving the legal underpinning of private law, and a constitution or a basic law in a liberal democracy is also involved at least in setting up the institutions like the legislature and the courts that allow the private law to be created and enforced, allow you to collect the remedy. But we're not bringing the full weight of the state to bear yet. So then we say, all right, at some point, we're more directly involving the state. At some point, some conduct is going to not merely be an issue of private law that the law is supporting, the state is supporting in that way, but the state is going to act directly on behalf of the people and prosecute this. So how do we decide that? And this is the article I gave you to read, or the chapter I gave you to read, on principles of criminalization. So if we can distill some of these principles, The first thing we're going to look at, and we've been touching on this a little bit in our discussion over the past few minutes, is the degree of harm. How much harm is really occurring? If I fail to deliver the load of bananas, there's some financial harm. And we don't consider that just trivial, but we don't tend to consider that the degree of harm that criminal law should punish. Whereas if I am drunk and driving and results in a fatality, maybe we do. It's a more significant kind of harm. Impingement on autonomy is in many ways related to harm. To what degree is the conduct that we're seeking to address impinging on somebody else's freedom? The degree of shock to the public conscience. And now this one sounds kind of nebulous, and in a way it is. And really these principles of criminalization are not sort of scientific principles. They're kind of ideas of the way we make judgments about certain things. So, fail to deliver the bananas, I don't think we would generally consider that a shock to the public conscience. It happens. There could be all kinds of, legitimate reasons why I couldn't get the bananas to you on time. Or maybe even I was just lazy or I just neglected it. That's not great, but it's not so shocking. Whereas, murder, that still is something that we say that shocks our society in such a way that it's a more important thing. And then related to that are these two. One is the de minimis principle. We want to generally only criminalize something as a last resort. We first want to try to say that civil remedies provide kind of the first resort. Because, again, we're not bringing the full weight of the state to bear. If we have to get there, then we will go to criminal remedies. And then a kind of final question, and I put a question mark here. Does morality or concepts of morality come into play here? Some legal theorists say that, yes, the more immoral we consider, the more seriously immoral we consider some kind of conduct, the more likely society is going to want to call it criminal conduct and bear the weight and bring the weight of the state to bear on it. Other legal theorists say no, law and morality are really separate things and don't really directly relate to each other. So that's something you'd want to kind of consider for yourself, and the extent to which morality does play into whether we call something criminal or not. All right, so let's say that we have an inclination that some area of conduct should be covered by the criminal law. What then? So then there are some other principles about how we craft criminal law. And the first principle is one of definition and drafting. We want the criminal law to be as clear as it can be, because we want people to know what is prohibited, what is a crime, and what is acceptable, what is not a crime. Because we're bringing the weight of the state to bear against individuals, we want to have some confidence that we're only doing that when somebody has really knowingly violated something that we're calling criminal. And to do that, we have to have it written clearly. Now, you should note that obviously most of us haven't memorized all of the criminal law. And I've been practicing law for over 30 years. I haven't memorized all of the criminal law. No one could really exactly do that. And we do have a principle in Anglo-American law that ignorance of the law is no excuse. So the idea isn't necessarily that everyone's going to actually literally know all of the law. But you can know enough to know certain things that are prohibited, and you can know enough to get competent advice that can tell you in some domain in which you might act whether something is on the line of criminality or not. The rule of lenity is a related principle, which is the idea that a court, in applying criminal law against someone, should interpret it, if it's ambiguous, as in the most lenient way toward the accused as possible. And when we talk about the question of access in excess of authorization under the Computer Fraud and Abuse Act, which we're going to talk about in a few moments on this video, that's kind of a place where you might say there's an ambiguity. What does that term mean? And one way that courts are supposed to be interpreting, say if I've got two different possible interpretations, and one is more favorable to the accused, I'm going to lean toward the one that's more favorable to the accused. And that in turn encourages legislatures to be as clear as they possibly can in their drafting. All right, potential for enforcement. It's not good to have criminal law on the books that is never enforced or very rarely enforced. That tends to undermine the rule of law and to foster a disrespect for the rule of law, and it also makes it unclear to people, what is actually criminal and what is actually the kind of thing the state cares about and what kind of thing the state doesn't. So when we're in a live class about this kind of question, I would ask, can you think of some things where there are laws on the books that are not enforced or rarely enforced? And, rightly so, I think one of the first things a lot of people think of is traffic laws, at least speed limits on certain highways. Now, speed limits aren't exactly a kind of criminal law. It's kind of somewhere between civil and criminal, but you could make a good argument that it really undermines the purpose of speed limits if the routine norm is everyone drives at least 10 miles an hour over and the cops aren't going to stop you. Another one people bring up, and rightly so, is marijuana law and the debate today in many states about legalizing marijuana. And part of the debate is, there is this law against possession and use of any quantity of marijuana still in some states and under federal law, but in general that is not enforced, or at least it's selectively enforced, which is even more of a problem. So it tends to be enforced more directly against low-income and minority communities and not enforced in white and higher income communities, and that creates a racial disparity as well. So we want a criminal law that is something that actually there's going to be some capacity to enforce. We have to think about the extent and the type of punishment, and you'd have to get here into deeper into theories of punishment. To what extent is the criminal law about retributive justice? Is the purpose of the criminal law punishment, or to what extent is it punishment? To what extent is the purpose of the criminal law about restorative justice and rehabilitating and restoring the person? So we have to think about that. And then really broadly, how consistent is this crime, this defined crime, with other areas of the law? Does it fit in reasonably well with private law, and does it fit in reasonably well with other areas of regulatory law? And here, let me go back to the example of driving while intoxicated or driving under the influence of alcohol. So there is a regulatory piece of that, which is part of getting your driver's license, which includes some education you have to have about driving under the influence and has the rules about DUI. There's private law there, because if you drive under the influence and you get into an accident and injure somebody, that private party could sue you for negligence. And then there's also criminal law, because at a certain level and certain number of offenses, it becomes more than just a mere traffic offense. It becomes a higher level of crime. And we could say, well, that fits pretty well together. There are different pieces of this that are trying to give different incentives for people to act in certain ways. So that's a bit of background on computer crimes and some ideas about what we want to criminalize and what we don't, and you can see the connection with the overall criminalization debate in the Aaron Swartz materials. But even given the Aaron Swartz materials, I think very few people would argue that there should be no computer crime law at all. Almost everyone, I think, recognizes that there are certain kinds of activities that are a real problem economically and socially, and are probably an appropriate subject for criminalization. And in the United States, at the federal level, the primary vehicle for that is the U.S. Computer Fraud and Abuse Act. Now, for those of you who aren't as familiar with the U.S. system of federalism, the United States federal government is the national government. Each individual state, like New York, New Jersey, and so on, also has its own sovereignty and its own government. And under the Constitution of the United States, the relationship between the federal government and the state governments is defined, and it gives certain powers, certain overarching powers to the federal government, and it reserves some powers to the state governments. So each state within the United States has its own computer crimes statute. In most of the states within the United States, if computer crimes are prosecuted at the state level at all, most of it is child pornography and some stalking and harassment. And we're going to come back to those topics a little later during this semester. Most of the economic crime is left to federal prosecution simply because the states don't really have the resources to do it. And then at the federal level, most of the prosecutions are either things that are sort of low-hanging fruit that they happen to catch, or are larger organized crime rings that they're trying to crack, or are connected with bigger international and foreign policy issues where the prosecution probably won't actually result in anyone getting extradited to the U.S. and convicted, but there are other reasons for making a statement about the prosecution. But in any event, the main statute at the federal level is this Computer Fraud and Abuse Act. And this statute is, the approach taken in this statute is similar to the approach taken in the European Union and in many other countries. And part of the kind of problem in a way with, or problems at the edges at least of this statute, is that it really was first created in the 1980s, which is well in the pre-public internet era, and is a time when companies might have had a big room full of mainframe computers running tapes and maybe some dummy terminals at desks. And so the main focus of the many parts of the statute has to do with authorization, whether the access to the computer was without authorization or whether the access to the computer exceeded or was in excess of authorization. And so you can kind of think of, are you actually authorized to walk into the big mainframe computer room and take one of the tapes? So that gets trickier in the internet era, in the era of cloud computing, in ways that we'll see as we look at some of the cases. And when you look at the statute itself, you'll see that there are 7 sections of the statute. Each section is relating to a different type of computer fraud crime or sort of related group of computer fraud crimes. And I'm going to go through in some detail each of those sections. So the purpose of reading the statutes and the case law that we're reading throughout the semester is, of course, to learn the law, because we want you to know what some of the law is in this area, but it's also to help you to learn how lawyers read statutes and how lawyers read case law, and to give you a little bit of the skill and a little bit of the ear for a lawyer looking at these things. And I think when you're faced with a statute like the Computer Fraud and Abuse Act or a case like Van Buren that we're looking at today, you get this sort of big jumble of information, and it can really be a little bit hard to process, even for first-year law students, even for well-practiced lawyers. But one of the things you want to look at is, are there terms that are used in a certain way in the statute that perhaps you think you know what they mean, but the statute is actually using them in some kind of a unique way. And in this case, in the statute, we're continually seeing this term computer, and we're continually seeing this term protected computer. And maybe when you read this, you think, I know what that is. But you want to think twice a little bit and check the statute and see if the statute defines those terms in a unique way. And if it does, that's the definition you have to use. And in fact, the CFAA does have definitions of computer and protected computer that are things you want to know about. So looking at the definition of computer, any electronic, magnetic, optical, electrochemical, or other high-speed data processing device performing logical arithmetic storage function. All right? A facility, data storage or communications facility included, but does not include an automated typewriter or typesetter, a portable handheld calculator, or other similar device. So a question I ask about this is, does this definition include this? Does it include your phone? And if you consider this definition a little bit and you ask, well, is this an electronic device? Yes, it's also optical. Is it a high-speed data processing device? Yeah. Does it perform these functions? Yes. I think it's pretty clear that this thing counts as a computer under this definition. Now, the interesting thing about this is in the 1980s, when this statute is first created, these things didn't exist. Nobody knew, really, that smartphones were on the horizon. So it illustrates how a definition could be broader in its initial inception and even later. Now, as you look at this, you see there is this exclusion of the automated typewriter, typesetter, or portable handheld calculator. Well, isn't this a portable handheld calculator? And if so, why isn't this actually excluded? And for that, you'd really have to dig into what did they mean by a portable handheld calculator when they created this definition. They weren't thinking of cell phones because they didn't really exist. They were actually most likely thinking of the old calculator you'd keep in your pocket for math class. So the definitions, even though they're specific, can be kind of flexible, and you have to pay attention to what they're saying. Even more important for our discussion, this term protected computer. And when we were all together in class, I asked for a show of hands, or a discussion about what do you think protected computer means? And the obvious answer that a lot of people gave was, okay, a computer with some kind of antivirus software or firewall or some other way protected from intrusion. That's a logical answer, but it's not what the definition has to do with at all. And what the definition means is a computer that is protected under law by this statute. And that includes, first of all, computers used by financial institutions or the United States government. That's the first category. That's a pretty narrow category. Most computers of private entities, of small businesses, would not be covered by this. So why is this definition in there at the time that this statute was drafted? First of all, financial institutions and the U.S. government were some of the main users of computers, and the financial system is really important to the working of the whole society, and of course the government is important to national security. But that's not the only part of the definition. The definition also includes this part B, used in or affecting interstate or foreign commerce or communication. This definition is what ties this federal law, or allows this federal law in the United States to reach economic conduct occurring between the states. And this gets a little bit deep into the weeds of U.S. constitutional law. But in short, the U.S. federal government does not have a general power to regulate the ordinary activities that are happening within a state. That's left to the state governments. But the U.S. government does specifically have the power, the U.S. Congress specifically has the power to regulate interstate commerce, that is, commerce that flows between the states. And so this means that any computer that involves activity, commercial activity that's flowing in between and among the states of the United States can be covered. Today, really, that means any computer connected to the internet. And we don't have time to get deep into the definitions of what commerce means and how you interpret the Commerce Clause under the U.S. Constitution. But the short answer is it's interpreted very broadly, and there's very little doubt that any computer or device like this phone connected to the internet is covered. So really, a protected computer is pretty much any computer, unless there's something really unique that is keeping that machine completely walled off from any outside network, and there's nothing in any way that connects it to interstate commerce. That's almost never going to happen. Notice the second part of this definition, including a computer located outside the United States that's used in a manner that affects interstate or foreign commerce of the United States. This provision gives this statute extraterritorial effect. And so what this means is that the activity could be happening physically initially in, say, Russia, right? The hackers can be in Russia or Ukraine. And the computers they are using to conduct the activity are in Russia or Ukraine. But they are attacking information that is used in U.S. commerce. And therefore, that activity is still brought within the domain of the U.S. Computer Fraud and Abuse Act. So it is still a crime within the U.S., even though some or all of the activity is physically occurring outside of the U.S. Now, the problem here, of course, for U.S. law enforcement is that you're very unlikely to be able to apprehend the people committing the crime and to extradite them, to bring them to the United States to stand trial. Certainly with countries that we don't have a clear and easy pathway to do that, such as Russia and China. Occasionally, there's stories of them catching a high-profile cyber criminal who's on vacation in Amsterdam or something like that. But in general, that's going to be the real barrier, not the territoriality of the crime, given the global connected nature of the internet. All right. Our next really important definition is going to be this question of access and what it means to exceed authorized access. So access without authorization is one way that in certain areas of the Computer Fraud and Abuse Act you can get into trouble. But you can also get into trouble if you have authorization of some kind, but you act in a way that it goes beyond that authorization. And the question here is, what does it mean to be authorized, to be entitled to access? Does it mean legally entitled? Does it mean contractually entitled? Or does it mean technologically entitled? And within the United States, in the federal appellate courts, there was what we call a circuit split. The federal appellate courts in the U.S. are grouped in what we call circuits. It goes back to the old days when the judges used to ride a circuit on horses. But the circuits are appeals from different groupings of states, right? And then the U.S. Supreme Court, sits above all of the circuit courts. And so in the different jurisdictions in which some circuit courts sit, there was a disagreement. Some of those appellate courts said, if you violate a contract or a policy document, so your employer says you have access to this customer database. Here's your password, here's your login. Our policy says you may only use this information in furtherance of the business of the company. And you, having that access, take the information and take a list of customers and start a competing business. All right, so you have violated company policy. Is that a crime that the Computer Fraud and Abuse Act would govern because it's in excess of authorization? Some appellate courts had said yes. Some appellate courts had said no, that's not a crime. We leave that to private law. That's a breach of contract claim. That's a trade secret claim. The company can file a claim if it wants. And this issue, because of this disagreements in the appellate courts, recently went to the U.S. Supreme Court and was decided in the Van Buren case that I asked you to read. So much like reading statutes, reading case law can be difficult. In many ways, again, it's kind of like reading a foreign language, and you have to get a feel for a method for breaking down what's important in a case. And so, again, part of the reason we're reading this case together is so you understand what the law is, what the rule interpretation is, but also so you get to learn a little bit of how lawyers read cases. All right, so when you're reading a case, the first thing that you really should be thinking about is what is the actual issue that this court is deciding. Now, as a lawyer who is bringing a case before a court, and a very important part of the lawyer's job is to actually try to frame the issue in a way that is, accurate but also beneficial to the position the lawyer's client wants to take. And there are different ways of framing an issue in a case. But then when a court has decided a case, if we wanted to figure out what the court actually did, first we have to decide what is the issue the court was faced with. Though I'm doing a kind of static video here, let me ask you to take a moment, maybe hit pause and think to yourself, what is the issue in Van Buren? Now, my guess is that if you thought about what the issue in Van Buren is, you might have thought something like, was Van Buren guilty of a CFAA violation? So fair enough, but that kind of thing is not really a precise enough statement of the issue. You might have also said, what is the meaning of exceeds authorized access under the CFAA? Again, fair enough, but you want to be a little more specific than that. The way I wrote out the issue in Van Buren was and by the way, when you're writing an issue, starting with the word whether is often very helpful. Whether a police officer who obtained information from a police computer he had credentials to access and used the information for an unauthorized purpose, a monetary payment, violated the CFAA's exceeds authorized access provision. So notice how I'm bringing in some of the facts of what the case is about with the legal question that's being asked. Now, the way I've stated this, I think you could actually state it a bit broader. I do mention that this was a police officer and a police computer. It may be that is not as significant. We might say whether an employee took information from an employer's computer or whether a public employee took information from a public employer's computer. I suspect that the rule that the majority of the court was adopting is meant to be quite broad, is meant to include all kinds of employers, not just police or public employers. But it could be that in a later case some distinction gets made. This is how cases work. This is how lawyers work. We make distinctions between what came before. All right. Second thing you want to try and figure out, to the extent you can, based on the information you have, is what is the procedural background of this case. Sometimes the procedural background is going to give you some clues into the sort of weight of what the court did, how meaningful it is for other cases that might be in a different context, or even of the rule that the court came up with. So in this particular case, the defendant has gone through a full trial on this crime. Now, this can be significant in a criminal proceeding. In U.S. federal criminal proceedings, ordinarily it begins with the prosecutors obtaining an indictment from a grand jury, which is just saying there's enough evidence here that there's reason for the prosecutors to bring the case. The prosecutors file the charges, and then the case is in a court, and then the defendant can, before trial, make a motion to dismiss the indictment on any number of grounds. It could be procedural reasons, it could be the way the evidence was collected. Later in the semester we'll talk about the Fourth Amendment, search and seizure, and the Fifth Amendment right against self-incrimination. Or it could be substantively. It could be that the crime as defined, the argument is unconstitutional, or the facts as stated in the indictment simply can't support the crime. But in this particular case, that's not what happened. It went to a full trial. And when it goes to a full trial, the judge is giving instructions to the jury, saying here's what the law is, and then a jury is making a determination. So Van Buren appealed from the jury verdict to the Intermediate Appellate Court, the 11th Circuit. The 11th Circuit agreed that the defendant was properly convicted. In other words, both the trial court's instructions to the jury and the 11th Circuit agreed that it could exceed authorized access for a police officer to obtain information the police officer technologically and otherwise was allowed to get in relation to their job, but to use the information in a way that violated a department policy. Then from the 11th Circuit, the case went up to the Supreme Court. Now, most cases that make it to the U.S. Supreme Court do so based on what's called a petition for certiorari. The intermediate appellate courts, in most cases, and certainly in criminal cases, are obligated to hear the appeal. You as a criminal defendant in the U.S. have an appeal as of right to the circuit court. You do not have an appeal as of right to the Supreme Court. Otherwise, the Supreme Court would be, unable to conduct business. It would be overwhelmed with every appeal in every case throughout the whole country. So the Supreme Court has discretion to hear an appeal or not. So you file a petition, and the vast, well over 90% of all these petitions are turned down. So very few cases does the Supreme Court hear. And in this case, the Supreme Court heard the appeal because of the disagreement among circuit courts in the meaning of this term, exceeds authorized access. So then the next thing you want to do when you're reading a case is get a handle on the facts. And it can be really useful for you as a learner, and even even as you become more proficient, even as an experienced lawyer, to really just kind of on a page somewhere write these things out: issue, procedural history, facts. The trick is to summarize briefly the broader set of facts that you have in the case. There's only going to be certain things that are really relevant to the holding. So I won't go through all of the facts of the case right now, but as you read these facts, they're a little bit tawdry. It should be pretty obvious to you that the police officer is acting in ways that is going to result in a corruption of the system. But the crime that he's charged with is not some kind of corruption crime, it's the CFAA crime. And part of what the court is doing in trying to define the bounds of exceeds authorized access in a case like this is to say, is this really a computer crime? And if so, how would that relate to other fact patterns in which there could be a computer crime? Or really, is this some other breach of public trust by this officer, which it may be some other crime, or maybe it's not a crime, but it's an internal disciplinary matter for the police, right? How are we going to handle this? All right. Then you want to define what is the holding of the case. So again, if you're watching the video, pause for just a second and think to yourself, how would you define the holding of this case? And my guess is either at this point you're a bit at a loss, I don't know how to do that, or you might say, well, the conviction was upheld. The conviction was overturned by the Supreme Court. That's not the holding, that's the result of the case. The holding is, what is the rule that the court applies? How does the court apply a rule in these circumstances? And I think in this case, the court, courts don't always do this, but the court kind of gives us helpfully a summary toward the end of the majority opinion by Justice Barrett. An individual exceeds authorized access when he accesses a computer with authorization, but then obtains information located in particular areas of the computer, such as files, folders, or databases that are off limits to him. So this holding is now a rule, is now the Supreme Court's way of interpreting what exceeds authorized access means. And so in future cases, this is the definition that we're going to use. Now, as you look at this definition, in the end, Justice Barrett says, this conviction shouldn't stand given the facts before the court. But you might want to ask, well, is this really a clear definition? Because what Justice Barrett could have said is that are protected technologically, right, from which this person doesn't have a decryption key or a password or something like that. Now, these and that could be part of what it means for something to be off limits, and these files, in that sense, though were not off limits to Van Buren, but as a matter of policy, the use of them was off limits to him. So there may still be a little bit of ambiguity, but what Justice Barrett is trying to do is to say, do you have access to these? So there may be a little bit of an ambiguity, but what Justice Barrett is trying to say is, do you actually have some otherwise legitimate access to these files? If so, then if you've misused them in some way, that's not a CFAA violation. Do you not actually have legitimate access to these files? If you don't, then accessing them can be in excess of authorization. You have access to other files on the system, but not to these. I think it's still a little ambiguous. Does that mean only a technological lock, or does that mean also could that also mean a policy? You are allowed as a matter of policy to look at this, but not to this. When you've sort of figured out what you think the holding is, you want to make some notes about why. How did the court reach that holding? What is the analysis that the court used? And here, Justice Barrett looks at the text of the statute and says, I think the plainest way to read this language is in the way that I have read it. She looks at the legislative history, which is, how is this statute passed? What led up to the passing of this statute? Were there any debates, or was there any evidence in Congress of what Congress might have meant by the term? And then she looked at policy concerns, and she considered, if I interpret this language more broadly to include unauthorized uses, are we then going to really ensnare a lot of people who are doing things like, maybe surfing the internet during lunch in violation of a company policy? Do we really want to call that a crime? Probably not. So she focuses primarily on the statutory text, but she looks at these other things. Now, you'll notice this is a U.S. Supreme Court case, and it's not uncommon at all that you'll have a majority opinion and a dissenting opinion, or one or more dissenting opinions. So the question I ask you is, what do you think the legal effect of the dissenting opinion is? And the answer to that question is 0. The dissenting opinion is not the law. The law is what is the holding and rule announced by the majority opinion. So who cares? Why do we read a dissent? Well, we read dissents for a number of very important reasons. Sometimes dissents kind of clearly point out limits of what the majority opinion may or may not mean for future cases. But often what dissents are doing is registering some points, some arguments that may come up later on in later cases. It may be that in a later case, the court overrules its prior precedent based on the reasoning of a dissent. A famous example of that in the U.S. is Brown v. Board of Education, one of the big civil rights cases in 1954 that said that separate but equal segregation is unlawful. Previously, the Supreme Court in Plessy v. Ferguson had said segregation is lawful. So sometimes the court does that. That's relatively rare. More often, you'll have a case that is a little factually different. Maybe it's not a police officer, right? Maybe it's somebody else. And then there's an argument about, does the same rule apply? And then maybe some of the reasoning of the dissent finds its way into the distinction that's made. So it's useful in a U.S. Supreme Court case to be reading and understanding the dissents. Finally, sometimes, and in a case like this, the Supreme Court is interpreting a statute that has been passed by Congress. The court is not saying the statute is unconstitutional. It's just interpreting the language. So Congress is free to change the language. And it might be that, as a matter of policy, Congress says, hey, we like the reasoning of the dissent better, and so let's change the language and make it more clear, what we actually want it to mean. And so that's another reason that dissents can be helpful and useful to read. So a final definitional piece, you'll notice that in various places the statute talks about damage. And in some places the statute has statutory thresholds, minimum amounts of damage before the federal law applies. So this definition, any impairment to the integrity or availability of data, program, system, or information. One thing to just note here, if you're in the security field at all, you'll probably know the CIA triad. So this is a basic principle of data protection. And it says that when we're looking at data, we want to have confidentiality so that we are able to keep the information confidential. We want to have integrity, which means that the information doesn't become corrupted. It still is readable. It still is, assembled or able to be reassembled. And we want it to be available, meaning that the information has a purpose. It's used for some reason. If it's a sales database, someone has to be able to look at that information and make, sales projections and budgets and so on. So these things have to really all be taken together. I mean, we could have perfect confidentiality, you can encrypt everything and throw away the key, but then we're losing integrity and we're losing availability. All right, so notice integrity and availability are mentioned here. Why is the C, confidentiality, not mentioned? And I think one of the explanations of that is that there are specific parts of the statute that make compromising confidentiality a crime. All right, but any impairment here is very, very broad. It's pretty easy to meet the statutory threshold for there being enough damage for this statute to kick in. Because impairment includes not only something happening to the integrity and availability of the data as such, it can also include things like remediation costs, the cost of hiring someone to look at the system and try and forensically figure out what happened. And these costs can pile up very, very quickly. So, jurisdictionally, when we looked at protected computer, almost any computer connected to the internet, the damage threshold, very easy to meet. Really, the thing that limits prosecutions under this statute is the resources of the government. The federal government simply doesn't have the ability to prosecute most low-level economic computer crime, or even most high-level economic computer crime. There have to be certain targeted things and ways that they go after it, and that problem of enforcement is another piece of the problem we address in a cyber law class. So now let's move into some of the specific crimes, or let's move in to discuss the specific crimes under the Computer Fraud and Abuse Act. And as we do this, we're also going to be learning a little bit about how lawyers break down statutes into manageable units or elements of the crime. So what you want to do when you're looking at a mass of language like this is you want to say, how can I break this down into a set of steps that a judge is then going to instruct to a jury about how to decide whether the crime was committed, or that an individual is going to look at and say, am I potentially running afoul of one of these? Or a prosecutor is going to look at and say, can I charge a crime? So we're going to look at different clauses in the statute to begin to do that. And here, first thing we can pick out is intentionally accesses a computer. And we can keep going and say, without authorization or exceeds authorized access. So these are our first two elements: intentional access, without authorization, or exceeds authorized access. Now notice that this talks about intent. We're going to talk about this a little bit more in the coming week, but criminal law is generally addressing intentional conduct. It's not usually addressing merely negligent conduct or even merely reckless conduct. Usually we say conduct that is reckless or that is negligent, that's a matter for the civil law, for tort law, for example. Although sometimes, and we will see even in the computer crime area, sometimes we do criminalize certain negligent or reckless conduct. But usually we're looking at intentional conduct. And at the very least, criminal law has aspects of what we call actus rea and mens rea. Actus rea is the action, what action was taken, and we're usually saying that's an intentional action, although again it could be maybe negligent or reckless. And then mens rea is what is the mental state of the person doing this crime. All right, so here we have intentional access is our action without authorization or exceeds authorized access. That is our initial bad act, and through that thereby obtains, and then each of these pieces here is a different third element to this crime, right? So intentional access without authorization thereby obtains one of these three things. So the first piece is certain kinds of financial information of a consumer, all right? The second one is information of a department or agency of the United States. See how this ties to the definition of protected computer? That first piece of that definition was financial institutions and U.S. government, right? So taking that kind of information is intentionally without authorization or exceeds authorized access is a crime. But then this third piece, information from any protected computer. So this first part of the Computer Fraud and Abuse Act is mere access and mere taking of some information. Now the way computers work today, any computer connected to the internet, simply in virtue of the fact of accessing, there is at least certain information being transmitted, being obtained. So it may be that you access without authorization or exceeds authorized access, and you go into a drive and you extract some files from that drive. That's certainly taking information. But even if you don't take anything, you are technically violating this information part of this statute. So it is a federal crime in the U.S. simply to access a computer without authorization or in excess of authorization, because that access in the internet era is going to involve some taking or exchange of information. Now, when we go through the penalties for the crimes, you'll see that the different kinds of crimes are at different levels of severity, and the different levels of severity result in different levels of punishment, different levels of possible jail time. So this is the lowest level of jail time, but it still is a federal crime that can result in jail time. Now, as we looked at the elements here, taking the statute, I'm showing you here how this looks in the U.S. Department of Justice Prosecuting Computer Crimes Handbook. And notice how all of this language has been boiled down and formatted into these much more simple elements. And this is what lawyers do, and this is what judges do with all of that language. So this is the handbook that a federal prosecutor would use to say, do I think I have grounds to charge this crime? Something I want you to observe about the way this test is formulated, and this is common to tests in the law. Sometimes we have a word "and," right? So with these elements, intentional access and without authorization and obtain information, that's a conjunctive test. That means each of those things has to be present. If there is not intentional access under this part of the statute, there's no crime. If there's intentional access, but it's not without or in excess of authorization, there's no crime. Right? If there's intentional access, without or in excess of authorization, and there's no obtaining of information, there's no crime. But as we have seen, the way computers work today, networked computers work, that's highly unlikely. So conjunctive test, using the word and. Then we may use the word or. And when we use the word or, that is a disjunctive. So we could have any one of the things listed present and still satisfy it. Now this can be a little confusing because we have and, it's a conjunctive test, or we have a disjunctive part of a conjunctive test. So you have to have this, and you have to have this, and you have to have either this or this or this. All right, conjunctive and disjunctive. So the next part we'll look at, and we're just going to go kind of briefly through each section of the Computer Fraud and Abuse Act, is accessing and defrauding to obtain value. And that's part A4. So here are our elements: knowingly and with intent to defraud, access a protected computer without authorization or exceeds authorized access, and by means of that conduct furthers the intended fraud and obtains anything of value, unless the object of the fraud and the thing obtained consists only of the computer and value less than $5,000. All right, let's break this down a little bit. Intent to defraud. So this word defraud or fraud is not specifically defined in the Computer Fraud and Abuse Act, but fraud is a well-known term in American law. And so if a statute is using a term that is well-known in American law and doesn't give it a specific definition, then we have to consider what does that term generally mean in the law. And generally speaking, fraud in the law is knowingly deceiving someone to obtain something of value where the person has no reason to know that the representation you're making is deceitful. So fraud is not merely telling any untruth. There is part of fraud that says the person who is the recipient of this conduct has a certain, is presumed to have a certain degree of reasonable knowledge. So, if I say to you, hey, I happen to have found the deed to the Empire State Building, and the building is worth hundreds of millions of dollars and maybe $1 billion. I'm short on cash. I'll sell it to you for $1,000. Am I doing it knowingly? Am I doing it with intent? Possibly. But would it be reasonable for you to actually believe that I have the deed and that I'm able to sell it to you? Probably not, right? So anyway, the whole purpose of this part of the Computer Fraud and Abuse Act is to say that a fraud crime involving a computer is its own kind of crime. All right, we already have fraud crimes on the books in general. So why do we have a separate computer fraud crime on the books? And the reason for that is it is a way, first of all, of indicating that there's a particular kind of fraud that we think is prevalent and important that we want to have criminal law about. But it's also to say that somebody can be charged with more than one crime. So you could be charged with ordinary fraud, and you could be also charged with this section of the Computer Fraud and Abuse Act. And there are going to be questions then about, how those relate to each other. Do you have multiple sentences? But this is a way that it gives prosecutors more to charge and more leverage potentially over a defendant. So notice here that we have conjunctive test. All right, you need this, and this, and you need this. But we also have a conditional, which is the word unless. So even if we have all these other things present, if one of these conditions obtains, then there's no crime. So what is the condition here? The condition here is basically a monetary jurisdictional threshold. So the original idea of this part of this statute is we're not going off. The statute is not meant to go after what we might consider low-level fraud or low-level computer fraud. Now, it doesn't mean low-level computer fraud is just okay and legal. It just means federal resources, federal crime aren't going to deal with it. Maybe state resources will deal with it, or maybe something else will deal with it. Now, the twist with this, as we have seen, is this question of value and damage is very easy to satisfy, and so even something we might consider low-level still potentially could trigger this statute. It would just be a question of whether prosecutors are actually going to take the trouble to try and enforce it. This then is how the Federal Computer Crimes Prosecution Manual breaks down and sort of reorganizes in a neat way those elements. By the way, I post all the slides, so you will have the slides to help you, work through a hypothetical or a multiple choice question or something like that. So then Part 5 of the statute actually contains 3 different possible crimes, which can make it a little confusing, but when you break it out, and I've just given you here to make it a little simpler, the actual breakout from the Computer Crimes Manual. This is a more recent, more contemporary amendment to the statute, because this is a malware provision, right? Knowingly cause transmission of a program, information, code, or command is our first element to the first part of the first crime under this part of the statute, and that is specifically designed at getting to malware. All right, and conjunctive, as a result, intentionally cause damage without authorization to a protected computer. All right, so intentionally cause damage, sending some malware to intentionally cause damage. As we've seen, the damage threshold is pretty easy to meet. But intent, what if you transmit some kind of program, information, code, or command, and you're not intending to cause damage, but some damage nevertheless is caused? Well, that's a place where this part of the Computer Fraud and Abuse Act goes a little further than the usual criminal place of intent. So notice that Part B talks about recklessly causing damage, and Part C doesn't say anything. It just says causes damage. So Part B allows a claim for recklessness if damage is caused. Part C allows a claim for negligence and perhaps even a strict liability kind of claim if any kind of damage is caused. So Part 6 is a trafficking provision. So trafficking in the law is thought to is a kind of commercial activity that is illicit. So human trafficking, right? You're trading people against their will, either for enslavement for manual labor or for sexual acts or prostitution, right? Things like that. So trafficking, computer password or similar information, knowingly with an intent to defraud, and that trafficking affects interstate or foreign commerce, or it's a U.S. computer. So selling passwords, selling decryption keys that you have stolen that you don't otherwise have a right to, or that you're otherwise selling as part of a scheme of fraud, violates the Computer Fraud and Abuse Act. And again, this interstate commerce hook is that jurisdictional hook that allows, or that hook that allows the statute to exist under the Commerce Clause and is interpreted very broadly. So this will include any trafficking in such information over the internet. Part 7 is the extortion part of this statute. And this extortion is, possessing something, usually that you're not entitled to possess, or that you came across illicitly, or that you're not normally entitled to disclose, or that through disclosing you're going to cause some particular kind of harm to a third party, and in exchange for not disclosing that information or for giving that information back to its rightful owner, you're asking for money or some other value. So intent to extort money or other thing of value, transmitting a communication through interstate commerce, again, anything on the internet, which contains a threat to damage a computer, a threat to obtain information from a computer without or in excess of authorization, or to impair the confidentiality, or a demand or request for money in relation to damage to a protected computer where the damage was caused to facilitate the extortion. So all of this language, it covers a lot of things, but the key thing you want to keep in mind that it covers is ransomware. So and it's multiple crimes usually under the CFAA to do ransomware, because you are probably transmitting a code, you are probably accessing without or in excess of authorization, so you have multiple levels of crime there, and then you have obtained some information and you're encrypting it and you're not giving it back, so you have impaired that information or damaged that information. And so this is the part of the statute that ransomware is charged under. Part A3 is the access to a government computer. So again, intentionally without authorization, access a non-public computer of the United States, and that conduct affects the use of the computer by the government of the United States. Why is this separated out from other access crimes? Because it will be a different level of penalty. In general, we're going to give a higher penalty if you're getting government information, because that can potentially affect national security. And then we have a separate part of the statute, actually the first part of the statute, specifically about national security information. And this is a pretty long and convoluted section. So to try and break it down into elements: knowingly access without authorization or exceeding authorized access, by means of that conduct, that access, obtain information that is determined by the United States government to be classified, to affect national security, right? So classified information. And obtaining that information with reason to believe that the information could use to injure the United States or to advantage a foreign nation, communicating, deliver, transmit, and so on, that information, or failing to return it to the United States. Now, a question I asked in class, and again, I'll maybe pause it and think for yourself for a second. Think about Edward Snowden. Think about the disclosures that Edward Snowden made after 9/11. Did Edward Snowden violate this provision? And we're going to come back and talk about some of that later in the semester. So, one issue would be whether he exceeded authorized access, in particular now as that is interpreted under Van Buren. The information that Snowden got, he was authorized to get. The parts of the computer information he got onto, he had access to as a contractor of the government. He obviously used it in ways that violate policy. Perhaps under Van Buren, then it's not a CFAA violation. So that's a question, right? Was the information classified? Yes, most of that information was deemed classified. Did he communicate it? He did, right? He communicated it to the Guardian newspaper. And did he have a reason to believe that it could cause injury to the United States or advantage a foreign nation? Now, his argument might be, I actually believed ultimately it would help the United States by allowing even lawmakers who might not have known about these top secret programs to know better and to allow the public to put pressure. But I don't think that argument would very much fly. A disclosure of classified information is usually going to be considered pretty much per se causing injury to the United States. All right, so that's a kind of summary of the different elements of the different crimes under the CFAA. This slide gives information on the potential jail sentencing for these crimes. And I don't want to go over this in a lot of detail, but let me point a few things out. The things that are not in parentheses, so here 10 years, or here 5 years, are for a first offense. The numbers that are in parentheses are for a second or subsequent offense. So as is usual in American criminal law, if you commit more than, you commit the offense again, the penalty goes up higher. And you'll notice that the potential jail, and these are maximum jail times, and there's a lot of different factors that would come into play about how much jail time a judge might give if you are convicted. And it's going to vary depending on severity. So national security information, which is considered a pretty severe offense, is a lot of years in federal prison. Mere compromise of confidentiality, could be as little as 1 year. Now, nobody wants to spend even a year in federal prison. Nobody wants to be convicted of a felony, which has a lot of other implications, but a lower sentence. So you can kind of look through this and see what the different sentences are. The most serious one is knowing transmission of, a code, virus, something else like that. Intent to cause damage, where there is an attempt to cause, or knowingly or recklessly cause, death. Now you might think that seems kind of far-fetched, but we will be talking about and think about things like attacks on water supplies, things like attacks on pipelines that might be cyber attacks, but that might have effects that actually could cause people to become ill or die, and that's a potentially very high offense. So all of these, potentially carry some jail time. Many of them, if you kind of are guilty of a number of different provisions here, can result in some very significant jail time, and that is one of the issues that was debated in the Aaron Swartz question. Given what he did, he was charged with a number of offenses that could have resulted in 20 years or more in federal prison. Is that too harsh, or is that appropriate? Those are some of the policy questions that you would discuss in terms of punishment under this statute. Okay, so that brings us to the end of this lecture. There are some hypotheticals that I handed out in class. I will make those available to you on the Brightspace page. We are, when we meet in person again the week after this coming week, I'm going to circle back to some of those examples, as well as to some other examples that other hypotheticals that I'm going to give you to look at when next week we have the online class and we talk about personal cyber crimes in the US. So again, I'm sorry I didn't have the live stream set up right. I will get that set up right in the future. I hope this video fills you in, and I look forward to seeing you all online next week.